person.
There's your numbers, and there's the one.
Ms. Tiley, can you hear me?
Yes, Your Honor. Ms. Webb will be sitting down in 1 second. Good afternoon, Your Honor.
Good afternoon. And for purposes of the video, can you hear me and also see me for the purpose of today's hearing?
Yes, yes, Your Honor. Your Honor, Mr. Little does have some difficulty hearing, so if we could keep the volume up from that end, that would be very much appreciated, and we can also relate things to him.
Very good. And then if there's an issue that you can't hear me, then you can let me know. I'll make sure that I can correct that for the record. Fair enough? All right. Thank you, sir. All right. We're going to go on the record then with respect to today's, this afternoon's docket. So we have case number 640008. It's the State of Ohio versus Samuel Little. Mr. Little, for purposes of today's hearing, there's going to be a few matters that I'm going to address, and I'm going to need to have your cooperation. This case has come before this court, and on a prior date, I have appointed counsel to represent you. For the record, on July 10th of this year, I appointed the Public Defender's Office. And so for the record, if those of you who are there in California, to just state your name for the record.
Samuel Little.
Thank you,
Mary
sir.
Kay Tiley and Terry Webb.
All right, so Ms. Webb and Ms. Tiley, for the record as well, before I begin to outline some of the procedures that will follow, have you had ample opportunity to speak to your client about today's proceedings?
Yes, Your Honor. We had an opportunity to speak to him by phone twice. We met with him yesterday and again this morning.
All right, thank you. And for purposes of today's hearing, does he waive his presence here in Cuyahoga County, the state of Ohio? Will he allow this proceeding to go forward by video?
Yes, Your Honor.
All right, thank you. For purposes of the courtroom, I'll have the prosecutor identify themselves for the record as well.
Thank you, Your Honor.
You're welcome.
Richard Bell for the State of Ohio, Cuyahoga County. Mr. Little, representing Prosecutor Michael C. O'Malley.
And can you hear Mr. Bell? Because I do have a microphone as he talks further that he can speak to. Could you hear the prosecution, Mr. Little?
I can hear some of it.
All right, so I'm going to go ahead and turn his microphone on just a little. Go ahead again, Mr. Bell. Thank you.
Oh, you could tell me what he says.
Okay, Mr. Little, we met before in Texas. This is Rick Bell. I'm the prosecutor that interviewed you there. I'll be representing the Cuyahoga County Prosecutor's Office. The prosecutor is Michael C. O'Malley.
All right, thank you. All right, so with respect to today's hearing, it's my understanding first that I'll move forward with an arraignment regarding this case. After conducting the arraignment, then I'll hear on the record from the state of Ohio regarding the change of plea that's going to be offered, and then in fact whether the plea will be accepted. The court will then advise Mr. Little of his constitutional rights before taking that plea, and then finally I'll move forward with sentencing. So again, arraignment, after the arraignment, discussions of plea, and then finally a sentencing. So with respect to your arraignment, Mr. Little, there are a number of rights that I want to explain to you. If there are any questions that you have, please ask your lawyers and they can ask and answer those questions for me. You have the right to know and understand the charges that are placed before you. My understanding would be, counsel for Mr. Little, that you've had an opportunity to share the indictment that has been handed up from the grand jury here in Cuyahoga County. Is that fair for the record?
Yes, Your Honor.
All right, so having the indictment shared with you, it's a total of 10 counts in the indictment. You have a right to know and understand those charges placed before you. You have the right to a trial by jury. You can waive that trial and try the case to a judge here in Cuyahoga County. Regardless of whether you try the case by a jury or a judge, the state of Ohio has the burden of proof, and they have to prove your guilt beyond a reasonable doubt. So that means Mr. Bell and his staff have the opportunity of presenting the case to a jury or judge, and doing so, presenting evidence. So what are your rights in Ohio regarding that evidence, Mr. Little? The state calls witnesses up to this witness stand, and they would have those witnesses testify. Your counsel can examine and cross-examine those witnesses. When the state is done with the presentation of their case, you may call witnesses to come in and testify. If either party's witness failed to appear, you can ask me as the judge to go out and arrest the witness. And we call that a bench warrant. So I could order someone to be arrested and brought in to testify either for you or the state of Ohio. Those are constitutional rights that you have, Mr. Little. You also have a right to remain silent. So nobody could force you to testify. No one could ever comment that you didn't testify. You have the right, sir, to a lawyer. And again, I've provided that opportunity through our public defender's office. There could be a fee for that, but that fee is waived because of your inability to pay. Finally, sir, the indictment that you have before you, your lawyers will speak on your behalf on 3 issues. The first issue would be, would you have the document in your possession for more than 24 hours? If you haven't, you could waive the 24-hour mandatory requirement. You could waive the reading of the indictment. So if you did not understand the 10 counts and your lawyers haven't had an ample opportunity to explain it to you, I could read the counts, but you could also waive the right to that reading. And then finally, I would have you enter a plea. And again, at the arraignment, I would have you enter a plea of not guilty so that we can proceed with the plea and then the sentencing. So counsel, on behalf of Mr. Little, would you like to speak with respect to the indictment before the court at this time?
Yes, Your Honor. We have received a copy of the indictment. We have had it for more than 24 hours. We are waiving a reading in open court, and Mr. Little is tendering a plea of not guilty to the indictment for purposes of the arraignment. Given his incarceration in the state of California, we are not requesting that bond be set.
All right. With respect to the case, then, no bond will be set with respect to his case. As the arraigning judge and the administrative presiding judge, I'll assign the case to my docket to handle today, as is the custom when I do early arraignment pleas and sentencings. So the case will be assigned to myself. With that being the case, there's a 10-count indictment. Count 1 being aggravated murder. Count 2 being aggravated murder. Count 3, 4, and 5 being kidnapping. Count 6 being aggravated murder. Count 7 being aggravated murder. And then count 8, 9, and 10 are charges of kidnapping. Those counts are before the court at this time. I'll note for the record that counsel for Mr. Little have filed for discovery. I know that was filed prior to the case being here on arraignment. Has counsel received discovery from the state of Ohio?
Yes, we have, Your Honor.
All right, thank you. So, Mr. Bell, at this time, it's my understanding then there'll be a potential change of plea placed on the record, of which I'll then inquire of Mr. Little and Ms. Kiley and Ms. Webb.
Thank you, Your Honor. Mr. Little, can you hear me where I'm standing?
See what?
Can you hear Mr. Bell, the prosecutor?
Right
now, can you hear him?
Yeah, I can hear him, but some.
Please let me know if you can't hear me as we go through this.
Ms. Kiley and Ms. Webb, can you hear Mr. Bell?
We can, Your Honor. We're ready to go, Your Honor. Thank you.
Okay,
Thank
go
you.
ahead. Thank you, Mr. Bell.
Yes, Your Honor, you are correct. We are here on a 10-count indictment, State of Ohio versus Samuel Little, case number 640008. The first count is for aggravated murder, Your Honor. There are other counts as well. Count 2, aggravated murder. Count 6, aggravated murder. And count 7, aggravated murder. These counts all have the same penalty that I'll be describing here in a moment. There's also the additional counts on the indictment, Your Honor. Counts 3, 4, 5, 8, 9, and 10 for kidnappings that are on this original indictment. It's our understanding that the defendant wishes to withdraw his previously entered plea of not guilty and enter a plea of guilty to counts number 1 and 6, the aggravated murder count with prior calculation and design. First of all, for count 1, causing the death of Mary Jo Payton, and then in count 6, aggravated murder for causing the death of Rose Evans. There is a mandatory sentence of life imprisonment with parole eligibility after serving 20 years of imprisonment on each of these 2 counts. It's our understanding that the defendant is going to be agreeing to plead guilty to these 2 counts, 1 and 6, and agreeing that they would be served
Are you able to hear Ms. Webb?
Yes, Your Honor.
Okay. And do you need any time with Mr. Little?
Yes.
Mr. Little wishes us to spend a
I
couple
want him to
minutes.
explain something clear.
Is there a possibility that the audio could be silenced and we can go off the record so you could remain to be seated and have conversation at the table?
Yes, sir.
All right, thank you for that. So we're going to go off the record here and allow the conversation to take place, but I'm going to remain on the bench, Ms. Tiley and Ms. Webb. If you need longer to have a discussion and we need to recess, then you could advise the court. So at this time, we'll adjourn, but I'll remain on the bench.
Thank you, Your Honor.
Thank you. Good, how are you?
Can you hear me, Your Honor?
Yes, thank you.
You're back on, sir.
Okay, so we'll go back on the record. So at this time, Ms. Webb, Ms. Tiley, have you had an opportunity to answer the questions that Mr. Little may have?
Yes, Your Honor. Yes, Your Honor.
Is there any position that's different at this time as I move forward?
No, Your Honor.
All right,
No,
thank
Your
you.
Honor.
Thank you, Mr. Little. Okay, so I'm going to ask Mr. Bell to continue. He had mentioned that the sentence range, I believe, before we took a break.
Yes, Your Honor. For the 2 counts that we understand that Mr. Little will be pleading guilty to on this indictment, aggravated murder, count 1 and count 6, the penalty is the same. It's a mandatory sentence of life imprisonment with parole eligibility after serving 20 years of imprisonment, with a potential fine of up to $25,000 on each count. It's our understanding that the defendant is indigent, and the state of Ohio will be recommending to the court with defense counsel that that be waived. The defendant will be agreeing to plead guilty to counts 1 and 6 with the understanding that they are to be served consecutively to each other for a potential sentence of 40 to life, and also consecutive to other cases which he currently has. Those cases, for the record and for Mr. Little, are the 2 Hamilton County cases from this morning, case number 1902957 and 1902543, as well as the Los Angeles County, California case of BA 400148, as well as the Ector County, Texas case of A-18-1415CR. Further, as part and parcel of this plea, Your Honor, it's our understanding that the defendant understands that we are reserving the right to charge him with the 3rd homicide in Cuyahoga County that he confessed to, and the state of Ohio will intend, after further investigation, to charge him with that. The defendant, Mr. Little, understands that the death penalty is not part of this case, that the state of Ohio has not charged him with the death penalty, as per our original understanding, and will not be able to charge him, nor will we, on this earlier admission to a 1977 through 1979 homicide. The defendant understands that there was no death penalty in Ohio at that time. It had been found to be unconstitutional, so he will not be charged as part of that case with any death penalty by law or by agreement. The defendant has received full discovery from the state of Ohio, and other than what we have spread here on the record, Your Honor, there have been no threats or promises in order to induce him to enter into this plea.
And Mr. Bell, I know that counsel for Mr. Little indicated discovery's been complied with, but you want to speak to discovery. Obviously they agree, but you did provide discovery to them, and so I don't know if you want to speak to that.
Thank you, Your Honor. The state of Ohio, with the public defender's Cuyahoga County office, has met and discussed the case. We've also sent to them all of the police reports and all of the investigator reports, as well as the interrogation of Mr. Little in Texas for them to see and for him to see as well. All that's been logged and also filed with the court, Your Honor. Thank you.
Okay, thank you. All right, so Ms. Tylee and Ms. Webb, is that your understanding of the change of plea as it's been outlined by the state of Ohio?
It is, Your Honor. I don't believe Bell specifically said that all remaining counts of the indictment will be dismissed in exchange for Mr. Little's plea to counts 1 and 6.
Yeah, so regardless of whether you heard, I believe it was stated in the beginning, but again, it is. So all other charges of the 10-count indictment would be dismissed. So he's pleading to counts 1 and 6. So the other counts that will be dismissed are 2, 3, 4, 5, and 7, 8, 9, 10. Those counts will be dismissed.
That is correct, Your Honor. That's our understanding.
Thank you. Is there any other thoughts or concerns that you want to spread on the record before I begin to inquire of Mr. Little?
No, Your Honor.
Thank you. All right, Mr. Little, I'm going to ask you a number of questions. Can you hear me at this level of speaking?
Yes, I hear you, sir.
All right, thank you. So there's a court reporter that maybe you can't see that's sitting over here to my right, and she's taking down the record. So everything that's said in the court is being taken down at this time by the court reporter. It helps protect you, the court, the prosecutor, if we ever need to go back and review the record. The reason I say that to you, sir, is because your answers will be recorded, and all I ask is that you speak loudly and clearly when you answer the questions that I'll ask of you, and that if you don't understand something, similar to what you just did, where you needed to speak to your lawyers, just let me know that you need to ask a question of them, and we'll take a minute to make sure that you understand anything that you have a concern with. Is that okay, sir?
Yes, sir.
All right, and then finally, if you have a question of me, something you don't understand, please make sure you ask, because at the end, I want to be very clear that your plea is being offered to this court knowingly, intelligently, and voluntarily. Okay, sir?
Yes, sir.
All right, so nice and loud, please state your name and age for the record.
All right, Samuel Little, at the age of 79, 6740, birth date.
What's the highest level of education you have, Mr. Little?
I have GED. What would that mean?
Okay. Do you read and write, sir?
Yes.
Okay.
GED, high school.
Okay, thank you. As you sit here this morning or this afternoon here, are you under the influence of any medications, alcohol, drugs, anything that would cause you not to understand what we're doing?
No, I'm not.
And do you in fact understand how I'm going to proceed this afternoon here in Cleveland? Do you understand that you're going to enter a plea of guilty to count 1 and 6?
That's the degree of understanding I have, yes.
Thank you, sir. Has anybody threatened you or forced you in any other way to have you change your plea?
No, sir.
Are you satisfied with the representation of your lawyers?
Yes, sir.
Now, with respect to the cases that you have already entered a change of plea, understanding that the sentence that I'll impose is an agreed sentence, do you have any open cases with other judges in either other states or here in the state of Ohio?
Yes.
Okay, so knowing that there may be other cases, you understand that those lawyers who may represent you in those cases will deal with those judges that you have to go before in order to decide how their sentence will be handed down. I'll have no say-so in how they should handle their case or what type of sentence you should receive. Do you understand that?
Yes, sir.
Okay. And sir, are you a United States citizen?
Yes, sir.
Okay, thank you. So let's go back. A few minutes ago, I explained to you your constitutional rights. And those rights, when I ask you for your change of plea, are going to be given up. So you are not going to have a trial in this case. And you understand that?
Yes, sir.
So let me just go through it again and make sure you don't have any questions. If you wanted to go to trial, Mr. Bell and his team would have the ability to then have to prove the case against you beyond a reasonable doubt. And that, okay, you understand it. So what I would ask of Mr. Bell and Mr. O'Malley and their team would be to call witnesses and present evidence. Before we did that, Mr. Little, you get to choose if you want a jury of your peers who would be called to the jury box. You and your lawyers could pick a jury, or you could give up a jury in Ohio and you could try your case to me as your judge. Do you understand that's a constitutional right you have?
Yes, sir.
Okay. So if the state of Ohio was asked to present evidence, as I said, witnesses would come up to this witness stand. They are sworn an oath to tell the truth. Mr. Bell and his team will ask witnesses for questions, and they would place their answers on the record. When the witness is done, you have a right with Ms. Tylee and Ms. Webb to examine these witnesses by asking questions, by cross-examining them, by asking questions of exhibits that they may try to enter into evidence. That's a right you have to confront and cross-examine witnesses. Do you understand those rights are going to be given up today when you plead?
Yes, sir.
Okay, let's go to your right after the state is done with their case. The state would rest. Judge, we're done. All the evidence would be admitted. Two things that you have that I'm going to ask if you understand that you're going to give up. You have a right to call witnesses in and have witnesses come up to here and testify for you. If a witness failed to appear, your lawyers could ask me to arrest the witness. And that's what we call compel them. So I can force them, arrest them through a deputy, and have them come in and testify. That's a right you have to compel a witness to appear. Do you understand you're going to give that right up when you enter your change of plea?
Yes, sir.
And then finally, Mr. Little, you have a constitutional right here in the United States to remain silent. Nobody could force you to testify against yourself. The state could never force you to the witness stand. Your lawyers could never force you to the witness stand. And in fact, sir, I could not force you to the witness stand. The state of Ohio could never use that against you. So they couldn't say to a jury, hey, Mr. Little didn't testify, so the guy must be guilty. Nobody could ever comment about your right to remain silent. Do you understand you give that right up when you change your plea?
Sure.
And I didn't hear your response. I'm sorry.
Yes, sir.
Thank you. Okay. Do you have any questions at all, Mr. Little, about giving up your trial rights?
No, I understand.
All right. Okay, so now, again, I'm going to follow some guidelines of the law here in Ohio. So I'm going to outline for you the penalties that Mr. Bell just spoke of, that your lawyers have already spoke to you about, but I'm going to make a record to make sure my court reporter has it on the record. So I'm going to outline the penalties, and then I'll ask you if you understand or if you have any questions. Okay, Mr. Little? Thank you. All right, so count one you're going to plead guilty to is an aggravated murder that you did purposely and with prior calculation and design caused the death of Mary Jo Payton. It's what we call an unclassified felony. Again, just so it's for the record, we have to go back to the law that was in place at the time of this murder back in 1984. So that's why we used the law from 1984. And back then, as Mr. Bell said, the death penalty was not on the books. It was not part of the law. So what the law said, and has already been outlined, is that your sentence is life in prison. On count one. Yes?
Thank you, Your Honor. I wanted to be clear. On the count that you're talking about now, death penalty was available. In 91 it was, Judge. The one that I was discussing about was the 77 to 79 murder, the third one, in which there was no death penalty in Ohio at that time. So
Was the 84 case?
Yes.
It was in the death penalty. I apologize.
And so the state of Ohio, Prosecutor O'Malley, gave Mr. Little, through me, a letter saying that we would not charge him on those 1984 and 1991 cases with the death penalty. I just wanted him to understand that in the 77 through 79, that it's not available in Ohio, just so he has full understanding.
Yeah, thank you for making it clear on the record. So, Mr. Little, I will step back and say, yes, as the law is in front of me for the 1984 and 1991 case, the death penalty was an option, but through negotiations from the state of Ohio and your lawyers, they have agreed not to charge you with the death penalty. And by charging you with the unclassified aggravated murder with prior calculation and design, now that I've read that to you and we've verified and corrected the record, the sentence is, on the charge that you're pleading guilty to, it's a life sentence, and it gives you the ability for parole after you serve 20 years, and parole eligibility in Ohio would begin after serving 20 years. That doesn't mean that you'll receive or a person would receive parole. It just means that it could be reviewed at the 20th year. So do you understand that you're going to plead guilty to the aggravated murder in count one of Mary Jo Payton with the sentence that I just outlined for you, sir?
Yes, sir. I understand.
Now, you understand there's a $25,000 fine that could be assessed. The state of Ohio has already noted for the record that they understand that the fee will be waived because of your inability to pay that fee. And you understand that as well.
Yes, sir.
Now, one of the things for the record that I'm, Ms. Tiley and Ms. Webb, at least I believe I'm going to state just to make sure I have a record, is today in Ohio we don't have parole, and that's post-release control. So I'm at least going to advise him of post-release control so I have it on the record. I don't know, have you had an opportunity to speak to him about that status and maybe possibly that I would cover post-release control with him?
We had not, Your Honor, but even under current law, his sentence would be a life sentence with the ability to receive parole rather than post-release control on these charges after serving a full sentence of whatever number of years.
Yes, as I outlined, but I believe just for purposes of the record and the Court of Appeals in the state of Ohio that I'm just going to advise him of the 5-year mandatory post-release control only because parole doesn't exist in Ohio. And so let's just say if he does ever reach a time where he is released, he would have 5 years mandatory supervision. That could be trumped by parole for a longer period of time, but I'm advising on the record 5 years mandatory post-release control with respect to the case. Understanding that may not apply, I'm going to note it for the record. Let's go to the remaining count 6. So count 6 is again an aggravated murder charge. You're going to plead guilty to aggravated murder for the murder on or about August 24th of 1991 that you did purposely and with prior calculation and design caused the death of Rose Evans. Again, Mr. Little, the sentence is life with parole eligibility after 20 years with a $25,000 fine that will be waived at the request and plea agreement by the state of Ohio. With respect to that count, sir, do you understand you're going to plead guilty to count 6 as indicted?
Yes, sir.
Okay. Remaining counts 2, 3, 4, and 5, 7, 8, 9, and 10 will be dismissed upon taking your change of plea to counts 1 and 6. With respect to your change of plea, there is also an agreement that the sentences would be run consecutive to each other. So that would make the 20-year eligible for parole eligible in 40 years. So 40 years is when you would be eligible for parole because of the consecutive sentence. So it's a life sentence, eligibility of parole in 40 years. And do you understand that that's the agreement, sir, that I'm going to hand down with respect to this sentence?
Yep. Yes,
Okay.
sir.
And then finally, the state of Ohio and counsel for yourself, sir, have agreed that your time would be run consecutive to the sentences handed down in the following cases. There were 2 cases in Hamilton County that you pled guilty to today. Case number 1902957, 1902543. There's a case in Los Angeles, California. That is case B as in boy, A as in Angela, -400148. And a case out of Texas, Ector County, Texas, A as in Adam, -181415 CR. My case and my sentence of life with eligibility of 40 years to parole will be run consecutive to those 4 other cases, sir. Do you understand that?
Yes, sir.
Sir, with that change of plea and the dismissal of those counts, the court would accept your plea and then move forward to sentencing. Do you have any questions about the 2 counts that you're going to change your plea to? Anything you don't understand, sir?
I understand everything said.
Okay.
I
You understand? I'm sorry, go ahead. I interrupted.
I understand and I agree to the proposition you gave on 6 and 1 with 1 and 6.
Thank you, sir. Okay, thank you. With respect to sentencing, after we're taking your change of plea, the court would move forward with sentencing. Again, for count 6, 5 years mandatory post-release control. He's advised of that today as well. Mr. Bell, moving forward with a change of plea, has the court complied with Criminal Rule 11?
Yes, Your Honor.
All right, thank you. Ms. Tylee and Ms. Webb, have I complied with Criminal Rule 11 here for the state of Ohio?
Yes, Your Honor. Yes, Your Honor.
All right, thank you. Mr. Little, I always like to explain just for a moment Criminal Rule 11 because you may be sitting there not sure exactly what I'm doing, and I always want to make sure the person before me understands. There are certain guidelines as a judge that we have to follow in making sure that we take a change of plea and we do it in a format that's inclusive of all the rights of the individual, and that I cover all the bases that the state of Ohio would want me to cover, as well as counsel for you, Mr. Little. So Criminal Rule 11 is really just asking the lawyers, did I follow the law, just to make sure that I didn't miss something. So counsel for the state and counsel for Mr. Little, thank you. Mr. Little, at this time, do you have any other questions before I take your change of plea regarding waiving your trial rights?
No.
Do you have any
No, I
questions?
don't.
Thank you. And do you have any questions about your change of plea that I'm going to ask you for with respect to count 1 and 6?
No, I have no questions on it.
Okay. And finally, sir, has anybody forced you, including this court, threatened you or promised you anything other than what we already have stated here this afternoon on the record to have you change your plea?
No.
All right, sir. Thank
No,
you.
but-
All right, so then this afternoon I'll note for the record that I'm satisfied that I've informed Mr. Little of his constitutional rights, that he understands the nature of the 2 offenses that he's going to change his plea to, the effects of that plea, and the maximum penalties that the court can impose. I'm also going to find that his plea this afternoon is being made knowingly, intelligently, and voluntarily. Mr. Little, on case 6400008, sir, how do you now plead to count 1, the aggravated murder charge causing the death with purpose and prior calculation and design of Mary Jo Payton, sir? How do you plead, guilty or not guilty?
Guilty.
All right, sir, I accept your plea of guilty and find you guilty. Sir, how do you plead to count 6, aggravated murder, where you purposely, with prior calculation and design, did cause the death of Rose Evans? Guilty or not guilty?
Guilty.
All right, sir, I'll accept your plea of guilty on count 6 and find you guilty. The remaining counts 2, 3, 4, 5, 7, 8, 9, and 10 will be nollied and dismissed at this time. Mr. Little, at this time, I'm going to hear from the state of Ohio regarding sentencing. So they'll have an opportunity to speak about sentencing. And then, sir, I have an opportunity to hear from your lawyers if they want to speak about the sentencing. And I have an opportunity to hear from you if you want to speak as well. So you understand that's how I'll proceed here at this time.
No, no.
Well, do you understand I'm going to hear from the state of Ohio? Yes.
Yes.
Thank you. Mr. Bell.
Okay.
Thank you, Your Honor.
You're welcome.
The prosecutor's statement today is Assistant Prosecutor Hannah Smith has been invaluable in assisting us in today's proceedings, and also by permission of the court, our paralegal Susan Jacobson, Your Honor. These are very old cases. Some people have asked, why? Why go forward with these cases if he's already serving time in prison? The state of Ohio, Cuyahoga County Prosecutor's Office, under the direction of Michael Lavelle, feels that this defendant needs to be held accountable for each of these crimes. So we've taken a position that he must plead guilty before this court, before Your Honor, to both aggravated murders, that there shall be no reduction for aggravated murder, and that there should be no reduction or agreement that these be held concurrent to each other or with anything else. The defendant, if his accounts are true, has killed 93 women across America. In my 30 years experience here, I've never seen anything like this or met anyone that was this callous during this reign, which was between 1970 and 2005. So this 35-year career of killing people indiscriminately and with purpose comes to an end because of law enforcement's efforts and Ranger Jim Holland, who the court has seen on camera here today. So we'd like to thank law enforcement around the country. We'd like to thank our Texas Ranger Jim Holland. I'd like to thank our prosecutor for allowing us to take this tougher stand against this defendant for bringing some accountability for the citizens of Cuyahoga County, and in particular for these two victims, Mary Jo Payton and Rose Evans. Both who were young, both who had their lives in front of them, both who might have brought something into this world that would have helped us further along our lives. And there's been a loss to Cuyahoga County, even though these cases are battling crime. So thank you for taking that into consideration and allowing us to come to your court and to enter into this plea and to take this 40-year life sentence. Thank you very much.
All right, thank you. On behalf of Mr. Little, Ms. Webb, or Ms. Tylee?
Thank you, Your Honor. Mr. Little would like me to read from the following statement. Mr. Little sincerely apologizes for the two Cleveland deaths of Mary Jo Payton and Rose Evans. He worked intensively with law enforcement officials to provide pertinent information which resulted in the resolution of the Cleveland cases. In pleading today and accepting life sentences, he wishes to provide closure to the families of the deceased women, as well as ensuring that no one else is falsely charged for his act. He is making amends in the only way possible under his current incarceration circumstances to provide any and all information which he possesses. Again, he sincerely apologizes for causing the deaths of Mary Jo Payton and Rose Evans.
And does Mr. Little would he like to speak?
Your Honor, Mr. Little would not wish to speak at this time.
Okay, thank you.
Thank you, Your Honor.
All right, Mr. Little, I think the few comments that I will say are pretty similar to the comment Mr. Bell just made and your lawyer. It does bring closure. This amount of time, I asked Mr. Bell, so are we going to have family here? And he said to me, Judge, these are such old cases that there aren't family that either we can find or that want to be here. And that just causes pause for anybody that would be here, is the effect of your actions, the heinous crimes that you committed against these women all across the United States have left many people with what I would say a hole in their lives because they didn't have an opportunity for closure. And there are some of those people who went to their graves not having closure. And this does bring closure to not only Cuyahoga County and to the city of Cleveland and to whatever family members that may still be alive for the Payton family or the Evans family. But it brings closure for you. You've accepted responsibility. You have been cooperative. But the fact that these families and those who love these individuals, who had an opportunity to miss them, as we would say, gone missing for so many years, this does provide closure, as the state said and as Ms. Webb said. 93 women and the pain and suffering that you've caused the families from 1970 to 2005, it's not even describable by myself. And again, as I think all of us here in the courtroom and anybody who would imagine that any one person could commit this type of crime over the course of 35 years is indescribable, unacceptable, and again, inhuman. And so, understanding you've accepted this responsibility, the court will hand down the sentence as the parties have agreed to here this afternoon. And with respect to count one, On behalf of the family of Mary Jo Payton, your sentence will be a life sentence, 20 years when you will become eligible for parole. On behalf of the count 6 and for the family, and on behalf of Rose Evans, a life sentence of 20 years, parole eligibility after 20 years. Those sentences will be run consecutive to each other for a life sentence with the eligibility of parole after 40 years. And again, a consent that the parties would waive any fines, fees, and court costs will be accepted by this court to waive any fines, fees, and court costs. The sentence will be run consecutive to the 4 cases as outlined already, in 2 cases in Hamilton County, 190-2957, 190-2543, Los Angeles County, 400-148, and the Texas, Ector County, Texas, 181415. So this life sentence with 40 years before eligibility of parole will be run consecutive to all of those cases. Again, count 1 and 6 will be run consecutive to each other. And again, post-release control, if it applies, would be 5 years mandatory. At this time, is there anything further from the state of Ohio before we conclude the hearing?
Thank you, Rick.
All right, thank you. Anything further from counsel for Mr. Little?
No, Your Honor, thank you.
No, Your Honor, thank you.
So, Your Honor.
All right, so at this time, I'll thank those who have helped with the ability to proceed by video. I appreciate the effort in doing so. And at this time, we'll conclude today's hearing. We'll adjourn.
Thank you.
Thank you.